Thanks for joining us for the Savvy Ladies Wednesday Wisdom webinar. I'm Maggie Montemuro, and I'm the Marketing Manager at Savvy Ladies. If you have any questions during the webinar, you can type them into the chat box. And if you're joining us by phone, email your question to info@savvyladies.org. Today's presenter is Jack Newhouse, Associate at Virginia and Ambinder, LLP. Jack concentrates his practice in the area of wage and hour class action litigation. He also represents workers seeking unpaid minimum wages and overtime compensation pursuant to state and federal overtime laws. Jack has been published on Forbes for his article on the impact of unpaid internship lawsuits on the internship job market. Following his graduation from law school, Jack became a member of Board of Advisors for the Center for Labor and Employment Law at St. John's University School of Law. Thanks for joining us today, Jack, and let's get started.
Thanks, Maggie. And first off, I'd like to thank Savvy Ladies for hosting me and allowing me the opportunity to speak on one of my absolutely favorite topics in the universe, which is wage protections and entitlements. I can't promise that this presentation is going to be riveting and that you're going to be at the edge of your seat the whole entire time. But what I can promise you is that it will be relevant. And just to prove it to you, I want anyone who's listening to raise their hand nice and high. I don't care if you're surrounded by your coworkers. If you've ever worked for anybody before, or if anyone has ever worked for you. I'll give you a minute to raise your hand. Now, if you're raising your hand in the workplace, put it down real slow so as to not hit one of your fellow coworkers, because if you do, you already need me. Today, we are going to be talking about wage protections and entitlements. And the first step in the process is to determine basically the types of workers that there are out there. So the question is really who you are, because in order to determine what protections you have, we have to know what classification of worker you fall into. And there are really only 4 classifications of workers. Now, there are lots of different names for the types of workers out there. So you got your advisors, consultants, financial representatives, vice president, CEO, lots of names, but they all fall into 4 categories. And that is an employee, a trainee, an independent contractor, or a volunteer. That's basically it. And the general rule of thumb is this: you are always an employee unless you fall into one of the other 3 categories. So if you're a business owner and you are hiring an independent contractor, which is a very common thing that happens, you better make sure as the business owner that that person that you're hiring is really an independent contractor, because the general rule of thumb, again, is that you're an employee. And now, there are 2 different types of employees. There are employees that are called exempt or non-exempt. And the types of employees that have the most protections under the law are non-exempt employees. And specifically, the protection that we're talking about is overtime. You may hear the term salaried. There are a lot of my friends, they'll say, okay, I got a job and I'm a salaried employee. But the term salaried doesn't necessarily mean that you're not entitled to overtime. The only people that aren't entitled to overtime are exempt employees. Non-exempt employees are, of course, entitled to overtime. And what's important here is that you cannot contract around your status as exempt or non-exempt. In fact, you can't contract around your status as either an exempt or non-exempt employee. It's based on the type of job that you have and your job responsibilities. So I listed here a few of the primary exemptions that exist. And so I listed the executive exemption, administrative exemption, professional exemption, and outside salesman exemption. To fall under what would be considered the executive exemption, your primary duties, this is basically your CEOs, people that are managing department heads, supervisors with real power. And because your primary job responsibility is managing an enterprise. And yet it's part of that is that you have to direct and manage the work of at least 2 individuals And you have to have the authority to hire or fire, and you have to have the authority to hire and fire. That's the basic test. There's obviously more to it, but that's the basic test. And so if you're an individual, and I see this all the time, where friends of mine that are specifically working in the consulting and finance industries, they're being promoted through the ranks. And so you come in, and you originally start out as an hourly employee, and then you become a little more senior and you start becoming exempt. Now the exemption status that you that the classification that typically makes that type of employee exempt is the executive exemption. But unfortunately, people who are 3-4 years working in finance and consulting jobs aren't necessarily in charge of hiring and firing at that point. And so it's important, whether you're a business owner or an individual that's moving up through the ranks in the financial industry, to really focus on the type of job responsibilities you have. And perhaps you'd prefer to be salaried, of course, but again, like I said, under the law, you're not allowed to contract around it. You're not allowed to say, oh, well, I'm an executive, I'm accepting a salary, let's put it in the contract and sign it. It doesn't work like that under the law. You're either exempt or you're non-exempt. The second one is an administrative exemption, and this is talking about in-house individuals that are engaged in the operations of a business. This is not that would include your accountants, your HR, high-level administrative assistants. And in order to be an administrative part of the administrative exemption, you have to be performing non-manual work that is directly related to the management or general business operations of an employer. And this is the important part, is you have to have the power to exercise independent discretion and judgment. And so the most difficult, I would say the most ambiguous classification of worker that falls under the administrative exemption are high-level administrative assistants, because there are some administrative assistants that are secretaries, and there are others that have a lot more discretion. So you may have administrative assistants that are in charge of ordering supplies for an office, and that person exercises discretion over how much supplies to order for the office, whereas an individual who's what I would consider a secretary under the law is maybe instructed on what to purchase. And that's an important distinction, is the amount of discretion an individual has, because if you don't have discretion, then you are a non-exempt employee and you're required to get paid on an hourly basis, including getting paid overtime. The next is the professional exemption, and that applies typically, that's your doctors, your lawyers, accountants, CFAs, individuals that have a higher level, that you have to receive a higher level education. And it really applies to individuals who perform work that require advanced knowledge in a field of science and learning. And it's a bit ambiguous, but again, the main standard here is that you have to have a higher level degree. And the last one is an outside sales exemption, which oddly, when I think of an outside sales exemption, outside salesman, I'm thinking of someone who's going door to door, selling vacuum cleaners or hats or something like that. But actually, it's a lot broader than that. It basically just involves anyone who's making any sort of sales, not in the place of business. And so the general rule of thumb is that if you're spending more than 50% of the time outside of the office making sales, then you're exempt from overtime. And so, my firm actually currently has a case against AXA, and they were, and because their employees were making sales, they're selling financial insurance products. Some of them were making sales outside of the office, and some of them are making sales from inside of the office. And now the employees that were doing the sales from outside the office more than 50% of the time are exempt, and they're not entitled to overtime. But employees that are working more than 50% of the time inside of the office aren't exempt, at least not under the outside sales exemption. Now, I just covered very quickly 4 of the main exemptions, but there are a lot of other ones. So I'll put my disclaimer in right here that please don't go suing your employer. Please don't make policies in your workplace based on the presentation, because this is really just a general overview of wage law. Next is a topic that has been very hot over the last few years is interns and trainees. The reason I put interns with trainees is because for the most part, interns have, well, not all interns, unpaid interns have to be trainees in order to be legally unpaid. Now, if you're an intern, you fall into one of three categories. You're either an employee, a trainee, or a volunteer. If you're an employee, then you're getting paid. So unpaid interns can only fall into two categories: trainees or volunteers. But as I'll explain later, really quickly, volunteers, you can only volunteer for a nonprofit institution. So if you're a for-profit institution and you have an unpaid intern, the only legal way that you can do it is if they fall under the classification of trainee. And now, in order to be a trainee, you must be part of a bona fide training program. In order to be part of this bona fide training program, the test for whether it is bona fide it's called the primary beneficiary test. In the Department of Labor actually has a different test that is a much stricter test. The primary beneficiary test really tests whether who's the primary beneficiary of the internship. Is it the intern or is it the employer? And if it's the employer, then the intern is really an employee. And if it's the intern, then the intern is considered a trainee. But the Department of Labor's test was very different. It was very strict. It's if the intern provided any beneficial labor whatsoever, regardless of who is the primary beneficiary of that labor. If they provided any labor, then they're considered an employee. But last year, a court of appeals, a federal court, came down and said that that's not the correct test. The correct test is this primary beneficiary test. And so it's not as if any one factor on this list is dispositive over whether an intern is a trainee or an employee. But if you go through this list, you see that the first one is mutual understanding about compensation. You don't want your interns showing up on day one to the internship program and thinking that they're going to get paid. But in reality, but then you say, oh no, it's an unpaid internship. There really has to be a mutual understanding that the intern is not getting paid and that there's no promise of future employment. It could be that all interns eventually get hired. That's fine, but it can't be a promise that you're going to intern here and eventually get hired here because you can't do it. That's what the court said. The next factor is the extent of training. It's because the intern has to be the primary beneficiary and they're not getting any money because they're an unpaid intern, then they have to receive a substantial amount of training. And one way that they show that is through credit, because that's the way that you tie the training that you receive at a corporation with the learning that an intern is getting at school. Other factors include duration. So let's just say you're an intern, you're working for a year and a half as an unpaid intern at a for-profit institution. At some point, you're no longer a trainee. I mean, not every job is like medical residency where it takes a year or two to figure it out, how to really practice on people. And a really important factor in the test is the extent the work complements rather than replaces the work of paid employees. And this is probably the most important factor, which is you can't have interns instead of employees. So if you have 16 interns and 3 employees and the interns are doing all the work, even if they're the primary beneficiaries, you cannot replace your employees, your paid employees, with unpaid interns. So I put together a list of what I would consider the best practices for having legal unpaid internships. And one is an absolute must is school credit. If you don't have school credit, you're going to have a hard time showing that you have a structured program. The second is keep it to a semester. It keeps in line with the schooling that the individual is in. Even if the class that they're taking the classes have nothing to do with the internship that you're providing, it's still to protect yourself from liability. You're going to want it to be matched up with the school semesters. The third is to have a structured program with goals, and I understand that this is probably difficult for smaller employers, but if you have a couple of interns, 2 or 3, have when they come in, at least for an hour or two, have some sort of orientation where you explain to the intern what they are going to expect, what they're going to learn over the course of the internship. who their supervisors are, where they can go, the type of work that they're going to be able to observe. And on that same note, you want them to be closely supervised. You want them to have a mentor, and make sure that they do have opportunities to shadow employees, because really the point of having an unpaid intern is to provide that intern with an opportunity to learn. And last but not least, with very few exceptions, there has to be very minimal filing and data entry work, because ultimately, again, it's about the learning experience for the intern. And so if you have the intern doing a lot of filing and data entry work with very few exceptions, it's not going to be that the intern is no longer going to be the primary beneficiary of the internship. It's going to be the employer who's getting the benefit of sort of what typically is mindless work. Next is a volunteer. This applies only to nonprofit institutions. It's an individual has to be doing it for the civic, charitable, and humanitarian reasons, which basically is saying that they have to do it on their own free will. And this is something that I think is so important, is that you can't pay your volunteers. You cannot pay them. You could give them a stipend, but once you pay a volunteer, they're no longer a volunteer. They become an employee. But if you give them a stipend, it's okay. And my recommendation for nonprofits that have that give stipends to their employees is to earmark it in some way, to basically just mark it as either for food or for travel, or for if they have to move to New York in order to do the volunteer position. I would earmark it to some extent. And the last is you cannot be in the regular line of work. So a nurse can't volunteer as a nurse in the hospital where she's working or he's working. The last is independent contractor. An individual, it's really a smell test when it comes to independent contractors, and sometimes it's very easy to know who is an independent contractor versus an employee. And the way that you figure it out is they have to be economically independent. So for instance, an easy person to identify as an independent contractor is, let's just say you're redoing your kitchen. The person you hire to redo your kitchen is going to be an independent contractor. They negotiated their rate. They're not bound to work for you long term. Usually it's not that long, depending on the size of your kitchen, of course. And it's not redoing your kitchen is not an integral part of you being a homeowner. Although for some people they may think it is, but it's not. It's not your business. Now, there are other ones that are much more complicated and not nearly as easy to figure out. So, for instance, an Uber driver. That's been in the news a lot lately, and Uber basically advertises itself as an app. They advertise themselves as an app that connects drivers to customers, not as somebody that employs drivers throughout the United States of America in order to make money. And one of the factors here is opportunity for profit and loss. And I'm not sure if this is true across the board, but in many places, Uber drivers really don't have any opportunity to negotiate the price for the transportation. And so there's a real question whether Uber drivers are considered employees. And so I think there was a case, one of the cases in California, the Uber drivers were winning, but in all the other states where there are lawsuits by Uber drivers as to whether they're employees versus independent contractors, they're losing, but it's a very close call. On the next page, I have a couple of additional examples of perhaps are they employees, are they independent contractors? And so I really like the first example, a gardener. If you're hiring a gardener to handle your lawn and they only come once a week, then they're probably going to end up being and they're negotiating their rate just like someone who's redoing your kitchen. That person will be an independent contractor. But if they're working for a landscaper, then they're being told what to do. They're not bringing their own tools, and perhaps they're not the ones getting the jobs. It's the landscaper that's getting the jobs and sending the gardener out there to do the work. So it's not necessarily also it's not so clear cut, depending on who you're working for. In an effort to move along, I'm not going to go through the other examples, but of course I'm happy to talk to anyone about it, about any of the other three examples if you feel like you fall under that topic or employ people that work under that topic. And so that brings us to the wage entitlements. Minimum wage is on the move these days. Starting in 2016, New York State's minimum wage is $9, but within New York State, now it's $9. In 2017, it's going up to $9.70. For small employers versus big employers, it is going to be different. So for New York City small employers, that's the 5 boroughs, a small employer is considered 10 employees or less. It's $10.50. For large employers, that's 11 employees or more. It's $11. What's important is that you have to get paid for all the hours you work. Let's just say you have a company, and the company requires that employees get authorization. You still owe them overtime if they don't get authorization, and you still owe them overtime if the employee decides that they got denied authorization and continue working. How to handle the very delicate situation is a whole different issue for another day. But the bottom line is this: if the employee is working, they have to get paid, whether it's overtime, minimum wage, or whatever the agreed upon salary is. You have to pay your employees in either cash or check, free and clear. At least minimum wage. You can pay your employees in other forms above and beyond minimum wage. So if you're paying someone, you could pay them $9 an hour in cash or check, and then you could pay them an additional $2 an hour in bananas. And it's not a joke, because I represented some individuals that worked at a grocery store, and the employer had represented to me that he was paying their employees overtime in groceries, including a substantial number of bananas, which of course the court didn't buy that, because you have to pay overtime and minimum wage in cash or check. Overtime means time and a half the regular rate, but the regular rate is not necessarily, it includes all earnings, and your earnings include salaries. It includes your salary, includes your commissions, and again, this overtime only applies to non-exempt employees. So if you have a non-exempt employee getting paid salary, they're still owed overtime. So that's salary, commissions, and tips. And something I didn't list on here is non-discretionary bonuses. A non-discretionary bonus is a bonus that you will get if you meet a certain it's non-discretionary. If you sell X number of items, you get X amount of money. And so that's a non-discretionary bonus, and that goes into your salary for the week. And you have to calculate the regular rate based on the total amount of earnings that you get. And then you divide it by the number of hours that you work, and that's your regular rate of pay. So just because you're getting paid $10 an hour doesn't mean on at the end of the year when you get your bonus, you should get paid overtime in accordance with $10 an hour. It could be higher. Earnings don't include gifts, holidays, sick pay, benefit contributions, discretionary bonuses, and so on. Spread of hours compensation really only applies to individuals who get paid minimum wage. And if you work more than 10 hours a day and you're getting paid at or about the minimum wage, then you have to get paid an additional hour's pay at the minimum wage rate. We see this all the time. I don't know any employer that actually pays it, but it's something that we bring in our lawsuits, and employers are required to pay it to employees that get paid at or close to the minimum wage rate. Restaurant workers don't need to get paid at the minimum wage so long as the tips get them to the minimum wage rate. And so tips plus your hourly wage has to give you minimum wage for all hours worked. Under New York law, instead of getting paid $9 an hour, you can get $7.50. Under federal law, it's actually quite low. It's $2.13 per hour. What's important for owners to know is that you cannot share in tips given to the food service workers, waiters, runners, so on and so forth. Compensable time. What is time that you have to get paid for when you work? Off the clock work, of course, you can't do it. If you're working and you're not getting paid and it's not on the clock, you have to get paid for that. That's obvious. But meals or rest breaks, a meal break is not compensable if you're not working. Short breaks of 5 to 10 minutes, you have to pay your workers. above 15 minutes. If you're taking a meal break above 15 minutes, you don't have to pay your worker so long as the worker's not working. Training programs. If a training program is mandatory, then you absolutely have to pay the worker for the time they spend training. Travel time from home to work, which is really commuting time, you don't get paid for. From job site to job site, you have to get paid for. So if you go from home to work to job site 1 to job site 2 to job site 3 to home, you have to get paid between job site 1 and job site 3, not the commute to home. Now, let's just say you're flying. You fly a lot for work. If you're flying during your regular business hours, you have to get paid your regular day's wage, whatever that is, based on the number of hours that you work or the salary. Waiting and on-call time. Now, if you're forced to stay at the work site and you're not able to use the time for yourself, then you have to get paid for it. If it's not going to be considered hours worked if you're free to do whatever you want. Having a pager is not enough. If let's just say you have a 3-hour break in the middle of the day, and you're allowed to go for lunch for 3 hours and do whatever you want, you don't have to get paid for that. But you do have to get paid if you're told to show up and stay until X time. You have to get paid for that. But in addition, for show up time, you have to get paid the lesser of your regular shift or 4 hours. So if you show up to work, your regular shift is 8 hours, and you show up to work and then they tell you to go home because they don't need you, then you have to get paid for at least 4 hours of work. Wage deductions. There are really only 3 categories of permissible deductions, which is tax withholdings, recovery of overpayments due to mathematical error, and repayment of advances. Now, every other type of wage deduction is permissible so long as it's for the benefit of the employee and the employee signs off on it. I recently heard of a pretty cool policy where instead of an employee who takes off too much vacation time, instead of being unpaid, so let's just say they take a week of unpaid vacation, instead of getting not unpaid for the week, they signed off that they could do a deduction to spread out the payments so that they get paid for the week and they have a check to pay their rent and for food. But their checks throughout the rest of the year are slightly less. And so that's something that I would say is for the employee's benefit. And as long as the employee authorizes it, then an employer is permitted to deduct wages in that manner. Really quickly, the Equal Pay Act basically prevents individuals of the opposite sex from getting paid different amounts if you're doing the same job. There are certain exceptions such as seniority, merit, certain incentive systems, but my recommendation if you're an employer is to have that merit or incentive system written down on a piece of paper or somewhere in like a policy, a handbook, because if you don't, then it's going to be very difficult to show that you're not favoring one employee over the other because you have some system. Because if you really have a system, it should be down on paper. Now, my only recommendation about not putting something down on paper is if you can't follow it, because the only thing worse than not having something down in a handbook is having something down in a handbook and not following it, because that's just such an easy way to get busted, really. Record keeping. An employer has a very high burden of keeping employee records. You have to record the hours your employees work, and you have to keep those records for 6 years. This is, I think, is so important, and I love this about New York law, is that at the time of hire, an employer is required to provide every employee with a written notice, exempt employees, non-exempt employees, it doesn't matter, that identifies your pay rate, the overtime rate, or your salary, your regular payday every week. And if you don't provide that employee with that information, then it's a $250 fine per day, up to $5,000, which can be enforced by the employee. And this is what the wage notice looks like. And I was actually looking at it, and it's actually wrong, because it says $60,000 in number 3. It says $60,000 per hour, which is clearly a salary. And there's actually another form out there. So if you have salaried employees and you want to start using this form, there's another form out there that says notice for salaried employees. You could see on the top, this is the notice for hourly rate employees. Then there is the records that you have to provide an employee every week, or during every pay period, I should say. It could be every 2 weeks as well, which indicates the hours worked, amount paid, deductions, net wages, and if you don't provide that information, it's a $50 fine per day up to $5,000. And this is what just took a standard pay stub off the website. But if you could use any payroll system, ADP, um, uh, paychecks, whatever it is, and they automatically will provide you with this information. Okay, and that brings me to my final slide, which is my advice to employers is basically to maintain accurate records. That's the most important part, is maintain accurate records relating to the type of work that your employees are doing, to the hours that they work, the amount that they're getting paid, because at the end of the day, the burden is on the employer, not the employee, to keep this information. It's under New York law and federal law. They put a very high burden on an employer to make sure that the employer knows the laws, and it's really for the protection of employees. You should have an employee handbook. Again, like I said, don't have a handbook if you can't follow any of the rules in it. But if you have a business and you can follow the rules in your handbook, then you should have the handbook. And if you're operating in an industry where your employees don't speak English, or some don't speak English, have it in a different language as well. And if you're not sure, ask, because ultimately, at the end of the day, there is a lot of liability, not just to the corporate employer, but also individual employers. That includes owners of a business. And so taking the time to ask your lawyer, your accountant. The DOL stands for the Department of Labor, will really help protect you, yourself, your business, in the going forward in the future. And so I know that I breezed through this as basically as fast as I could. And there's so much more to be said about wage protections and entitlements. And so obviously, if you have any questions, I'm happy to answer them now, or you can feel free to contact me after the presentation, and I'd be happy to talk to you about any specific situation.
Thanks, Jack. I just want to remind everyone that if you have a question now, you can use the chat box, or you can email info@savvyladies.org. And one of the questions we had come in during your presentation is, can you give an example of what or how much money will be an appropriate stipend for a volunteer?
Yes, I've seen nonprofits. Again, it depends on what if you're earmarking it, it gives you a lot more leeway. So if you have an individual who you want to earmark it for food in New York City and travel in New York City for the summer, maybe somewhere between, and perhaps even living expenses, for a portion of them, you could do somewhere between $500 and $1,000 as a stipend per month, maybe. That's what I would recommend. But if you're giving them $3,000 for a summer internship, for a summer volunteership, then that might be, and you're not earmarking it to anything, then that could be questionable.
Okay, thanks. And the next question we have is, do you suggest that if you receive a separation agreement from your employer, that you have an attorney review it before you sign it? Are separation agreements negotiable?
Absolutely, absolutely. The whole purpose of a separation agreement is to protect the employer, the company, from liability. So they may give it, an employer may give it as a common policy to every single employee, but it's going to have, most separation agreements before negotiation will make the employee waive every single right they have, will prevent an employee from ever suing the employer for any reason, even if they don't know about it at the time. And so especially if you left an employer under not such great terms, and you're contemplating perhaps recourse, doesn't have to be legal recourse, just any recourse whatsoever, then I would highly recommend having an attorney review it. And most attorneys will, at least initially during a consultation, will look at it briefly for free before giving any sort of advice. So there's oftentimes not much to lose.
Okay, great. And I believe this is our last question. It's, If I want to dispute my wages with my previous employer, do I need to hire a lawyer? I'm worried I can't afford one, and I just want to get paid what I'm owed, which is about $1,000.
That is an excellent question. You don't need to hire a lawyer. You can, of course, dispute your wages on your own, but lawyers that represent employees in wage lawsuits do not charge. Do not charge. They don't. The law is written in such a way that allows the lawyer who's representing an employee to bill, if they win a case, to bill the employer. In wage suits where I represent employees, I bill on an hourly basis. And if at the end of the case we win, we submit a bill to the court, who then submits that bill to the company that we're suing, and they're the ones that pay us. And so we never charge our clients anything. And let's just say the judge doesn't allow for the bill to go through, then the client will pay a contingency fee of some sort. But typically, I would highly recommend if an employee wants to raise a dispute, at the very least, initially talking to an employee, a lawyer, because again, it's free. Might as well get more information.
Okay, good advice. Well, I want to thank you, Jack, for an excellent presentation, and I want to thank everyone who joined us today and asked questions. We hope that we'll be seeing you again. And thank you again so much, Jack.
Thank you so much, Maggie.
Bye-bye.
Bye.